everyone. Thank you all for being with us for this very important conversation on the new Chilean Constitution. My name is Marta Blackwell. I'm the Vice President for the Canadian Council for the Americas, and it's really our great pleasure to be collaborating on this event and the coming series of events with the Universidad Diego Portales, and particularly Professor Domingo Lovera, who's with us today and will be moderating one of the panels. There's been a lot of conversation about the new Chilean Constitution, and one of the areas that we haven't seen much conversation on is really kind of placing the new Constitution into a conversation on the evolution of constitutions globally and highlighting sort of other constitutions that you can make comparisons with, others that are sort of seen as the most advanced and how they have evolved over time. So we wanted to look at that in context on specific clauses as they're coming out and as these conversations are evolving in Chile. So we've got a really amazing panel or set of panelists with us here today. We're going to be dividing the conversation into two separate panels. The first will be on property rights. And we have Professor Carol Rose from Yale University and Professor Larissa Katz from the University of Toronto. And this panel will be moderated by Matías Guiloff from the Universidad Diego Portales. The second panel we'll get into will be on social rights and international investments. That panel will be with Professor Jackie Dugard of the University or Wits University in South Africa, and Nicolas Perrone from the Universidad de Valparaíso in Chile. That panel will be moderated by Domingo Lovera from Universidad Diego Portales. So with that, I am going to hand over the conversation to our first panel and moderator, Matías. So I'm going to ask the second panelist if you can turn off your cameras now, and I'll hand it over to Matías. Thank you, everyone, again.
Thanks, Marta, and hello, everyone. It's really a pleasure being this morning here with Larissa, and particularly Carol, whom I've known from a long time. And this is kind of a unique chance of talking about a fascinating topic because, usually you think of property rights as something that binds a lot of decisions regarding the use of resources. But now we are discussing how to establish property rules or property regulations without such binds or without not so much of those binds. So that makes it really interesting to discuss about property rights at this stage. And just before forwarding to Carol and Larissa, I would like to provide some context to this panel, talking about the main debates that have been that we have here over the last months dealing with the property clause in the new constitution. So our first thing is that this constitution was supposed to be drafted, and this was like the constraint, was supposed to be drafted on a carte blanche, like from anew, but at the same time, in order to include a provision in the new constitution, you need to gather a two-thirds quorum, a two-thirds majority. So at the beginning of the process, when you saw which was the composition of the Constitutional Convention, you thought, hey, there's a lot of things you can make with the property clause. But however, when you see the end product, my impression, I don't know if Carol and Larissa share this impression, is that, there has not been such a lot of things being made with this clause. But I don't know, that's kind of my opinion. It's not some kind of an abrupt departure as it could be given the existing constraints. But dealing with the debates, a lot of debate has focused on the regulation of expropriation in the new constitution. But I think that debate has arisen. The cause of that debate stems not so much from this new provision, but from the drafting of the old one, which was very specific and consider a lot of details that are not usually included when you see the regulation of expropriation in other constitutions. So that would be a first point that has been an issue where there has been a lot of debate. Secondly, and also concerning the expropriation clause, there has been a lot of debate about this idea of the fair price or just compensation, because before the clause said that you had to compensate the effective damage that the expropriation caused. And this was always interpreted as being market value. So that has been an area where there has been also a lot of debate. Last two areas that I would say that had been debated would be, as always, the issue about the social function of property, or as Professor Gregory Alexander terms it, the social obligation clause, which also has changed in the sense that now it's not as detailed as it used to be in the 1980 Constitution, and it also includes a reference to the ecological function of property. And lastly, the last area of debate is that you know that the provision that regulated property in the 1980 Constitution was very long. And why was that long? Because at the end, it contained a very specific statute dealing with property rights, dealing with the use of some strategic resources, such as mineral resources and water rights. And now, in the new Constitution, the regulations concerning the use of such resources are not anymore contained in the property clause. So I would say that those are the four most the areas there where there has been more debate. And with that, without further ado, I leave you with Carol and Larissa.
Matías, who do you want to go first?
You, Carol.
Oh, okay. So I was asked to discuss the property clauses of this proposed constitution. And I do think the clauses raise some issues, some of them that Matías has spoken of. Oh, I would like to say one other thing too. I was introduced as being from Yale. I also have an affiliation with the University of Arizona, and I wanted to make sure that that got noted as well. So the property clauses, I do think they raise some issues. I think a number of other issues about property are going to come from other parts of the Constitution. So I hope that you will stay on to hear about the social and environmental clauses in the next hour, because I think those also impact the property clause. I'm going to start with an obvious question, which is, why have a clause protecting property at all? And my own view about this is that protecting any kind of rights is not just about rights in the abstract, it's rather that rights should do something for us. In this, I think I differ somewhat from Larissa, who is more of a Kantian, but I'm not. I'm just a utilitarian, and I want to see, I would like to know what it is that our rights are supposed to do for us. There are a lot of claims about this. A very important one, and probably I'll be focusing on most, is economic. That is that owning property, having secure property, encourages labor and effort and contributes to people's personal ability to make economic progress into the larger economy of a nation. There are other reasons. Some are political. Property is said to diffuse power, to give property holders the independence and autonomy that they need to participate politically. And then there are personal reasons. Property allows people to acquire and to keep things that have special meaning to them. Individual items, the wedding ring is an example that's been given, but there are others as well, your dogs or cats, your house, and so forth. And I think there's something else that is not talked about a great deal, but that is that it's educational. Property is all around us. We see lots of people with property, and learning to respect the property of other people is a kind of education in learning about and respecting the rights of others. So those are all good things, but property rights can come into conflict with other rights and other political concerns. If we're balancing property against those other rights and concerns, again, I think we have to ask, what do we want those balances, those mixtures of rights to do for us? So now let me turn to the clauses in the Constitution. Are they going to protect property so that property can perform the functions that we want? And how do they play off against other rights and other social and political concerns that we also want? The beginning clauses are basically that everyone should be able to acquire property in pretty much all kinds of things, and it includes among persons, evidently corporations, legal persons as well. By thinking about that in the context of other constitutions, that seems a fairly conventional way to look at property. There are some exceptions and some limiting clauses, as Matías pointed out. One clause says very generally that the limits of property can be defined by law. Now that's a pretty big statement, and it could be interpreted to mean that there's no way that a property owner can challenge legislation because legislation is part of the law that defines the limits of property. And I'd say, well, okay, that is a matter of interpretation. It would be a constitutional choice. And that would mean there would be no such thing as a takings clause, such as we have in the United States. And the takings clause has certainly put the brakes on a number of environmental efforts, like regulations that prevent buildings from going up wetland areas, or require developers to build bicycle paths or other things that we want for environmental well-being. Before deciding that there would be no cause of action for property takings, at least in these areas, one ought to remember, however, that property rights can be an important safeguard for other things that we also consider human rights. I wrote a paper not too long ago on the relationship of property to human rights, and I came to the conclusion, among other things, that taking property away from unpopular groups is sometimes the first step towards other human rights violations. And it's a first step that's not only economic, but it's also a form of humiliation and disregard. So it's important to remember that property is important for other human rights too. Now let me go back to these clauses. Another limitation or exception is that some things can't be made into property by nature or by what the law and constitutions declare is not capable of being appropriated. There are, as Matías pointed out, there are likely to be some issues about those. And here is where I think the issues are going to involve other parts of the Constitution. Let me give an example. Article 14A, and at least in the version of the Constitution that I have, it's not about the property. It's about things that are environmentally important. It describes beaches, that is waterfront beach property, as common to everyone in the country. So, okay, now here's an example of how that could play out. Suppose you have a hotel. And the question that you have is, can my hotel claim the beach area or a part of the beach area for my patrons? Can I put out beach chairs that are exclusively for the use of my patrons? Or can I have a bar that's on the beach that's just for my patrons? Now, if I can't, my hotel is likely to be less attractive to tourists. And that diminishes the value of the hotel property to me, to other investors and owners. And in a larger picture, it reduces tourism as an industry. Not a lot, but just at the margin, just a little bit, but margins add up. So the answer to that question, can I fence off or can I just use a part of the beach for my exclusive property? The answer to that question is it's going to be a choice. It's going to be a constitutional choice, but choices have costs and they have benefits. Indirectly, the hotel example brings up some of these other parts of the property clauses, particularly about expropriation and just compensation. Now, as Matías has said, there's been controversy about that in Chile. So just compensation is a conventional phrase in other courts and constitutions. The exception was Chile's earlier constitution, which was extremely specific about property. Most constitutions aren't that specific. But generally, as I think the Chilean discussion, at least the parts of it that I have seen, as that's pointed out, is that just compensation generally means market value. Not always, but generally means market value. That's true in contracts as well. James Gordon, a professor now at Tulane, has talked about the just price, going back to medieval times, as meaning market price under most circumstances, not all, but most. Okay, let's suppose just compensation means market value. Other rights in the constitutions are going to affect the market value of property. Now, let me go back to my hotel. Suppose the courts say that under the Constitution, my hotel can't claim any part of the beach for the exclusive use of my patrons. I can't put out beach chairs for my customers and have them just for my customers. That's going to make, it's likely to make the hotel less valuable to me. Now, suppose later the government wants to remove the hotel to create a park. What is just compensation to me? If the hotel can't use the beach exclusively, then the compensation is not going to be as much. And that's what I mean by saying that other parts of the Constitution affect these property clauses. And beyond the individual owner, as I said, there's going to be an impact on the economy. There could be less investment in beach hotels, less tourism, less money for tourism taxes, less tax money to fund other public programs like education and health, or even maintenance of the beach. That's my main point. It's not that these other things are unimportant. They are important. The constitutional clauses are going to have an impact on property, but they're important too. And the thing that we need to be thinking about is what is the balance that we want between these different important matters. But in taking into account the other important matters, there is an impact on property. Let me go to a couple of other examples. Pardon. The Constitution explicitly aimed, this Constitution is very explicitly aimed at protecting social rights and environmental rights. There is, in other clauses, not the property clause, but in other clauses, there's a right to a residence, there's a right to social insurance in cases of injury, unemployment, old age, there's a right to health and access to health services, there's a right, importantly, to a healthful environment. Those are obviously all good things, but they are not free. They cost money. And they again raise practical questions that bear on property rights. Who is going to pay for achieving these social rights, and how is that payment going to be made? Let me give the example of a right to housing. Now, in many places, including the United States or many parts of the United States, tenants get protections against eviction. They can't be just turned out of their rental housing, except perhaps for cause. There's been particularly the case of an eviction moratorium during the COVID period, but that's temporary. But let's say something more permanent. Let's say you can't evict a tenant without a court order saying that you have just cause for doing so. For the landlord, the owner, this means hiring a lawyer and waiting for the courts to make a decision. And that means that the landlords have to bear the costs of the housing when the tenant is not paying rent. That could have consequences. First, it raises the cost of doing business as a landlord. And second, it makes property less desirable for investment in rental housing because the costs of rental housing are higher. And there is a third consequence over a longer term, and that is that there may be less rental housing for tenants, generally speaking. There may be fewer people who want to use their property for rentals. They use the property for something else that will bring in more income. And if there is less property devoted to rentals, then tenants are going to have fewer choices, and the choices they have will cost them more. So this is not to say that tenants should not get protection. They should get protection. It's just to say that there may be a cost to this manner of providing for a social right to housing. It's not the only manner for providing a social right to housing, but it is one that's fairly commonly used. And that method puts the costs on, at least in part, on property owners of rental properties. So for a legislature in implementing a right to housing, it's important to pay attention to those costs and how they are assessed, and what the long-term consequences might be of whatever method is chosen, and then weighing the costs of that method against the benefits that come from it. One can make the same set of observations about the very desirable social rights that this Constitution seeks to guarantee, other than just housing. How are they going to get paid for, and who pays? Those are questions that do affect property rights. My guess is, from looking at other parts of the Constitution, is that the expectation is that the payment for most social rights is going to come from taxes, and that the heaviest taxes will fall on the wealthy, and that the taxes will grow heavier as you grow wealthier. So that means that when people acquire property, the more they get, the greater portion will go to taxes for social services, among other things. And one can easily say that's only fair. If you have more wealth, you have more obligations. This is what Matías referred to as Greg Alexander's point, that you have social obligations to pay more too. But there can be ripple effects. Let's say a young woman invents a new computer application that improves the safety of electric vehicles. Excuse me just a moment. So that's a good thing. Electric vehicles are better for the environment, and we want them, of course, to be safe. The more money that she makes from her invention, the higher portion of her revenues she is going to share with government for social services. And the next question is, what impact is that going to have on her economic activity? Now, for some people, she's not going to care. She thinks, yes, I make more money, but I owe more too because I am making more money. But some other entrepreneurs might not take that view. And insofar as their businesses are mobile, they may go someplace else. And if enough businesses go someplace else, there's not enough left for taxation to fund these very desirable social programs. All this is what I mean by saying that property rights are likely to be affected by other parts of the Constitution that support other kinds of rights. And I want to stress, it is important to remember that those are also significant rights, and that our task, or that the task of any Constitution, should be to look at property rights in a practical way and balance them with other rights and other social concerns, and to find a balance and a mixture so that all of these rights and concerns add up to what we want them to do as well as we can. And that balance might change over time. So the growing economy might strike a different balance from a mature one. But the important thing, again, as I say, is to consider a property in balance with other socially desirable programs, and to find a mixture that maximizes the total social benefits while being fair to individuals. So that's as much as I wanted to say, and let me hear what Larissa is going to comment on all that, and on, of course, her own comments.
Thank you very much, Carol. So it's the turn of Larissa now.
Well, thank you so much, Matías, and thank you, Marta, and everyone for inviting me. Carol, it's an absolute honor to be on a panel with you. Carol is the goddess of property law, as we all know, and it really is great to be able to be here with you today. So, you know, when I think about constitutional moments like Chile is having, I think about what Chileans are feeling right now, and I imagine that they're feeling something along the lines of, what does this Constitution make of us as a people? Right? This is a blueprint for how we want to live together, and what does it make of us that we sign on to something like this? And so while, of course, as a non-Chilean, I can't say much about that, I can say a little about the Canadian experience with its constitutional processes and its constitutional moments, particularly 1982, when we adopted our Charter of Rights and Freedoms. And I can say, I think, put a little bit of maybe offer a little context for thinking about the place of property within a constitutional framework at times like these. So it always comes as a surprise to my property students, inundated as they are with American, popular culture and television shows, to realize that we don't have constitutional protection at all for property rights other than Indigenous rights in our country. they always leave class feeling a little less secure and holding onto their coats and walls a little more tightly as a result. But the reality is that we have never in Canada and in the common law constitutional tradition of which we are a part, enjoyed written constitutional protection of property. So what do we have? We certainly have property rights. We certainly are, I would dare say it, we are a capitalist country where property rights matter quite a lot for all the reasons Carol has said, and where foreign direct investment is very important. And of course, local investment is very important. So what do we have if we don't have written constitutional protection of property rights that has allowed us to flourish as a liberal democracy with scope for the kinds of investment that characterizes a mature capitalist society in the 21st century? So first of all, we have a rich tradition of unwritten constitutional principles, which operate as principles of interpretation of legislation. So these unwritten constitutional principles are what courts apply in interpreting or construing a piece of legislation, a statute, that has the effect of taking property. So the courts, in interpreting legislation, presume that the state intends to compensate for any taking of property. At the same time, courts recognize that the state has the power to take without offering any compensation at all, if it states that intention clearly, expressly, and unambiguously. So to the extent that the state, the legislator, has not clearly and unambiguously expressed an intention to expropriate property without compensation, the courts presume an intention to compensate for that taking. Okay, so that's the first thing, is these rich presumptions have in fact been the backbone of our jurisprudence on expropriation, and they've been very effective because, as it turns out, in Canada, it is rarely the case that, although it will be the case, and I'll touch on this at the very end, it is rarely the case that there is a taking of property without, with an intention to not compensate, just to take and to leave the owner empty-handed. All right, so that's the first point. Really, this important, rich tradition of unwritten constitutional principles of interpretation. I can imagine all of you are saying, oh my goodness, this leaves a lot of power in the hands of judges. We'll get to that also a little bit more in a moment. So the second important backbone of our constitutional jurisprudence is the lens that the courts apply to the very problem of takings. What is a taking anyway? In the Canadian tradition, the kind of government action that amounts to a taking of property and expropriation is a government action, piece of legislation typically, that enriches the state at the expense of the owner, not just action that destroys value in the hands of the owner. So here we have a model of state-owner relations in Canada in this kind of common law constitutional tradition that is worried with something that is very much wrapped up with the ideal of the state, what we call the crown up here still with that nod to feudalism, with the idea of the state as committed to justice and honor. So it would be contrary to the state's presumed character as committed to justice and honor to be unjustly enriched at the expense of its own citizens. And so the courts, in scanning legislation, looking for takings, are looking for legislative action that enriches the state at the expense of the owner. So rather than acting as an arbiter, spreading the cost of a public project fairly across the citizenry, which I feel is sometimes the model in the US, right, where we're trying to make sure everyone bears their fair share of the cost of an important public purpose, right? In Canada, the concern is really to safeguard the honor of the crown, to make sure that the state never is unjustly enriched, because that would just be contrary to the very essence of the state and its very claim to legitimacy. Okay, and so that actually rules out some kinds of regulatory takings, right, where there's just a destruction of value but no enrichment. And the third really important feature of our constitutional jurisprudence on takings is this commitment to takings through legislation only. So this prohibition on executive takings. So those are, in effect, takings by the exercise of prerogative powers by the executive. So only clear legislation can extinguish rights. Executive action can never. By the way, for those of you who followed the Brexit, situation with Theresa May's attempt to kind of claim it prerogative power to extinguish rights, this was running in parallel, these arguments that no, there can be no executive action that on its own is going to extinguish rights that have already vested. Only legislative action, only Parliament can extinguish rights that we have that are vested, like property rights. So this goes back, centuries, the idea that no man's property can be legally taken from him or invaded by the direct act or command of the sovereign without the consent of the subject, given expressly, i.e. I consent, you can have my property, or impliedly through Parliament. So this is considered to be a jus indigeni, and Carol, you can correct my Latin there, but it's the idea that it's a kind of innate right. Okay, that there can be no taking of property except for with consent, which is implied through legislation, right? And then we add on top of that these judicial presumptions of an intention to compensate. Why? Because that's to safeguard the crown's honor. It's not really about the subject, but so much about the state itself and its character, that it would just never do for the state to be unjustly enriched at the expense of its own subjects. Okay, so against this background of what I consider to be a quite rich constitutional tradition in the common law, very beautiful as well, we have some efforts at constitutional reform starting in 1982. So 1982, we had a Trudeau as our prime minister, as we do now. It was Justin Trudeau's father, Pierre Trudeau. The Liberal Party was in power. We had this constitutional moment. Hey, maybe we should have some written protection for fundamental rights. Not a bad idea. So there were a lot of conversations about the kinds of rights that should be included in the charter. The Liberals, with Pierre Trudeau at the helm, very much favored including property rights under Section 7 of our charter, which is rights to, life, liberty, and security. Property probably would have been a nice addition there. However, property was deliberately left out. And the reasons are, as reasons often are, quite complicated and political. So for one thing, the Liberals didn't have a lot of support from the other parties. Well, from the NDP, the party that is perhaps more to the left of the Liberals, didn't support the inclusion of property because this would be, of course, a roadblock, as Carol put it well, a brake on regulation, right? And then the provinces, we are a society, a federalist system. The provinces who have constitutional power to legislate, to regulate property, didn't want property constitutionalized. They thought it would, take away their power to regulate property provincially. So there was a lot of resistance from various, different sort of groups to the idea of including property. And Pierre Trudeau, who was always the ultimate, realist, wanted to just get this done. And so he agreed to leave property out. Now, there were, of course, I think, other and richer reasons for this. At the time, the sort of intellectual climate was favoring kind of a move away from sort of old school liberalism towards something more like communitarian, social democracy, welfarism. And so there was a sense that, property rights were regressive and would get in the way of the Canada that we wanted to be. So certainly there was that in the background too. But mostly I think it's a political story that people tend to tell, right? The provincial or the federal Liberal Party, the Liberal government was already facing a lot of backlash, was not in a strong bargaining position, didn't think property was worth, falling on their sword for. And so they just kind of let it drop. Okay, so what does that mean? Well, it means that we've got what we've always had, right? Which is that we have rich unwritten constitutional principles and we have legislation. So constitutions aren't everything. Constitutions are just a blueprint. They're by no means, the end of the story. And as Carol has already explained to us, most constitutions are very thin in terms of what they say about our property rights and the protections they offer. So in Canada, every province and territory has an expropriation act. In fact, we've had legislation like this since 1883. And the legislation tends to replicate US-style takings protections. We also have many international treaties, NAFTA, or the now CUSMA, I guess, but the old NAFTA agreement again, right? It provides US-style expropriation protection for foreign direct investors, creating perhaps a two-tiered system where local investors are subject to local levels of protection, but at least the foreign investors are protected in the style to which they have become accustomed in the South. Okay, so that's sort of the background, unwritten constitutional protections, ideas about the very nature and character of the state, what kind of a state it is that we have in a common law constitutionalist tradition, one committed to honor and justice, one that could never be supposed by courts to intend to take your property without compensating, a commitment to legislative action if there's going to be a takings, never through executive action alone. Okay, so does this leave a lot of power in the hands of courts? Well, I mean, we have three strong branches of government. The judiciary is important. Of course, the courts have power, but courts have power that is constrained by office. We have general, protections against the arbitrary exercise of power by any branches of government. So I'm not sure that courts present a particular concern more than, for example, the executive or the legislative branches. Now, I should also note that the legislation, the expropriation acts that we have in each province and territory in Canada, leave a lot of the nitty-gritty decisions to administer to arbitration. For example, the equivalent of the Ontario Municipal Board, that the tribunals that are charged with deciding things like whether the compensation was fair. So the expropriation acts always provide for something called a hearing of necessity, which allows for a closer look at whether an expropriation in a particular case is fair, sound, and reasonably necessary in the achievement of the objectives of the expropriating authority. So administrative law is really important here, right, to operationalize these pieces of legislation. So it's not really the courts so much as these administrative tribunals that are making a lot of decisions. I should point out that only 5% of hearings of necessity that have been brought have been successful. There's a lot of deference given to legislators in this, right? So if you want to think of where the locus of power is, it's with the legislators, not with the courts or the executive. Okay, now, in a system like ours, it is true that there will be legislative decisions to take without compensation from time to time, right? So there have been cases where, for instance, the legislator has determined that it is expedient to expropriate and not to compensate. And this is almost never with respect to land or anything tangible, but there was, for instance, a decision taken not to pay interest to veterans for pension monies that hadn't been released in a timely fashion. The interest is, in a sense, a kind of a property right, or something that follows from a property right in the pension fund. It was a trust. And the decision not to pay interest was a takings. And the legislator just simply said, we're not compensating. And that is constitutionally valid. So it is, of course, possible for, in the absence of constitutional protections, US-style constitutional protections, for legislators to clearly, expressly, and unambiguously declare their intention to take property without compensation. Sherry Metcalf at Queen's University did an empirical study of whether in Canada this kind of gap between the legislative and the constitutional protection had been exploited in Canada, and determined that there was no difference in outcomes between the US and Canada in terms of the frequency and the adequacy of compensation for takings. Now, are we just, relying on good faith up here? Well, as I said, it's a constitutional choice to make, right? Whether you want to locate the power to constrain the legislator in private hands or the power to constrain private owners in public hands. These are constitutional choices we make. In Canada, we've made the choice to leave it with the legislator. We tend to be very happy with our state up here and not too distrustful of their intentions. And it has worked well so far. That's not a promise or a guarantee that it will always work. But then constitutional guarantees don't always work either. So I suppose what I would say is, Matías opened the session by pointing to, this is, Chile's moment. This was meant to be a blank slate. Look, we have some continuity. I would say that there's always going to be continuity in constitutional reform. There's never really a blank slate. We're always hearkening back to ideas we have about state-owner relations, ideas we have about the very nature of the sovereign or the very nature of the judge and their appropriate roles. And all of this matters just as much as whatever's written down in a constitutional text. So if you have a robust understanding of the state as, a persona that is artificially kind of, created, it's an abstraction that is then infused with certain characteristics like commitment to honor and justice, which the courts then have responsibility for enforcing, you end up with rather robust protection even without, the written text. So I suppose the Canadian experience tells us that what ends up in the written version of the Constitution is certainly not the whole story with respect to the integrity of property rights in a country, a liberal democracy with a capitalist economy, that we need to look to legislation, we need to look to international treaties. All foreign investors are going to rely more on these treaties than they are on domestic constitutions or legislation anyway. And we need to look at traditions, right? The way in which unwritten principles shape our relations with our governments. And so I think I'm happy to stop there and to talk more in question and answer, but that's the, I apologize for the top speed. I realize that I'm always trying to get as much out as I can in the shortest possible time, but I hope that was comprehensible and I look forward to your questions.
Thanks, Larissa and Carol, for this incredible presentations. Very interesting topic. We have some questions. We have first, I don't know if you want to gather these questions or just go one by one. We don't have that much at this moment, so I guess we can go one by one. And if we do have more later, we can devise a better administrative method. So the first question would be, how would these new property regulations affect infrastructure concessions? So we follow, I don't know, maybe Larissa can start now, and then Carol.
So I'm not sure I get the full scope of the question, right? So how does the new provision affect infrastructure concessions? So
yeah.
I suppose the starting point would be, to what extent are these concessions property rights? And that requires, of course, an understanding of their status within Chilean law, which I'm not competent to speak to. So, generally speaking, when we look at entitlements, so sort of state granted entitlements, right? There's always going to be this question of at what point are these just tradable and valuable interests that are not property, and at what point can we say these tradable and valuable interests are property? So we have live discussions in Canada about that, right? So our Supreme Court of Canada, and an important decision, the Sawney decision, has treated these questions, right? At what point can you claim, even without constitutional protection, even within the kind of, framework of NAFTA or legislation, at what point can you claim that a valuable interest of yours is property? Now that is a step before you get into any questions of, what compensation is owed for the, the taking of those. I think Carol probably has more to say about that than I do, though.
Carol?
Well, actually, I don't. I thought I have some of the, I'm not entirely certain what the what the question is about either, but I think Larissa is right about whether one issue will be whether concessions are considered property at all. Another is, again, echoing something that Larissa spoke about in her presentation, whether these are investments from foreign investors or whether they are domestic. If they are foreign investors, they're definitely going to be working under international law principles. They will get concessions written into their contracts and it will rely on international legal principles to decide about what kinds of concessions are compensable and what the compensation should be. I don't think you can tell from the general terms of the Constitution now what is likely to happen. I would think what the concern might be is investments that have been made in other countries from time to time, or foreign investments where the local nation has nationalized the property and then decided the compensation should be minimal. But once again, I think that now there are international treaty obligations that constrain that. And then there are longer term constraints, and the longer term constraints are that you, in some ways, can't do that for very long and continue to get any investments. So that there's a kind of a self-enforcing compensation. It's not a clause, it's just an obligation that countries have to pay attention to, or they lose foreign investment. Now, sometimes that's something that is not considered to be so bad. That is, that foreign investment has been, some countries might think it's been a blight, that foreign investment has done the wrong things for the country. They don't care if others don't get involved in it. But if you do care, and oftentimes you do, then there is self-enforcement on expropriation of investments for infrastructure or for anything else.
Thanks, Larissa and Carol. Yeah, the last point about those constraints, I think it's really important, and I mean, it's really kind of a factual concern, and it's not kind of something written, and it's very strong. So there's another question. How does, this one is addressed to Larissa, how does Canada deal with Indigenous versus non-Indigenous people rights? The Chilean proposal gives a lot of new rights to Indigenous people in detriment of non-Indigenous people. For example, Indigenous will have water rights, while non-Indigenous people will have authorizations to use water rights only.
So I can say this about our Canadian approach to Indigenous rights. So Section 35 of our Constitution protects the property rights, Aboriginal rights, which are property rights of Indigenous people in Canada. It's the only constitutionally protected form of property. And there's a story to that, right? So the thought is that while state-owner relations where settlers are involved, follow a certain logic, right? So there's a kind of sense in which settlers are claiming their property rights of the state and are, have a claim to the enforcement of those property rights by the state. Indigenous people, while of course they're citizens of Canada, have actually claims of their own to, sovereignty and to self-government that have been very sort of difficult for within our constitutional order to kind of accommodate. And so through property, we try to get to sovereignty here in Canada. And so we do offer very strong and exceptional protection of Indigenous property rights, in my view, as a proxy for recognizing what we can't recognize, which is their claims to self-government or sovereignty. So the reason we can is Canada, it claims sovereignty over the territory that is now Canada, and that is, in a sense, to the exclusion of any other sovereign. So property has a very special place in allowing Indigenous people their space to pursue their own ends as a people. And this is very important. So, we have a saying in Canada, we're all treaty people here. We all support the rights, traditional rights of Indigenous people. And so there's not a lot of pushback for that. There's not a sense that it's to the detriment of Canadians that we are trying to carve out more space for Indigenous people that is currently there. So again, constitutions tell us a lot about what we are as a people. The fact that in Canada, we really promoted Indigenous rights without, advancing our own, I think says a lot about us as a people. And it's been a long path towards truth and reconciliation in this country, and we're not there. But certainly this is something where you see a lot of support in this country for Indigenous claims. So Indigenous people do have rights to, water and to other sort of traditional rights that require licenses. So fishing rights, for instance, where you would have to have a license if you are non-Indigenous. If you're Indigenous, you may be able to claim this as an Aboriginal right that then takes you outside of provincial legislation or other legislation that would govern and regulate the use of fisheries, for instance. So that's a long answer, but I think it has to do again with just, what Chileans are as a people and how they conceive of their relationship to their Indigenous people and the relationship of the Indigenous people to the state. And so I wish you, all the luck in that, because that's actually a very, of course, important and fraught, set of questions. And I have to say, as a Canadian, I'm very proud that we are taking truth and reconciliation very seriously up here.
Thanks, Larissa. So we have the last 3 questions that are addressed to both of you. I will say them now. First 2 questions. First 2 questions are kind of questions of comparative property rights regulation. So the first is a question addressed to Carol. When you talked about this provision in the new constitution, which was also contained in the 1980 constitution, that law shall establish the limits of property. And you say that that's kind of different to what you have in the US, and that might imply that the constitution does not recognize the category of regulatory takings. Perhaps isn't the point that, in the US, you don't have a kind of a social function or social obligation clause as you have here that allows law to set the limit. But the thing about takings is kind of a distinct issue in the sense that in the US, the idea of regulatory takings was built through interpretation. It took kind of several cases to get there. So would you agree with that? That there are separate issues. What you don't have in the US is a provision giving kind of an authorization to the legislature to establish the limits of property. That would be the difference. But as for takings, in Chile, with this new clause, as in the US, it would be an interpretive matter. That would be the question. And for Larissa, you said that in Canada, the executive cannot take property. There's kind of a prohibition to do that. And the question would be, what happens to those cases? There's kind of self-executing laws are quite exceptional. Almost always things worked out in a way that, I don't know, if you want to protect the environment, certain endangered species, for instance, the law will establish certain administrative agencies that can do some kind of stuff and will establish the powers of those agencies. For instance, the power to declare as an endangered species that must be preserved. And then it's the executive agency with the knowledge of the facts that determines the specific species that is forbidden from exploitation. Would that be complicated in Canada? Would that be forbidden? And the last question is addressed to both of you, and I guess it's kind of a closing question for this panel. It's not only what the constitutional text provides that matters, but also the way in which the courts adjudicate legal and constitutional principles, doctrine, etc. But trying to make an abstraction, if you come across a property clause like the ones in the draft, would you say that there is a move to a totalizing state disrespectful of private property, or is it, on the other hand, a reasonable clause? So that would be the last questions.
Whoa. Let me say about the takings, the regulatory takings, this has been very much a matter of interpretation over time. I have to say, I'm sort of envious of the constitutional principles that Larissa speaks about. No explicit protection for property, but a long tradition of honor and ethical proceedings that actually does protect people's property. On the regulatory taking side, this is a work in progress. It has been for some time. I have to say, I am not a fan of many of the decisions about regulatory takings. I think they're overly rigid in some cases and don't give much guidance in others. And so I do wish we had what Canada had with respect to this. Canada is so perfect. It's really it's a shame that we can't get Canadians to come down here and run things for us. But I saw the other question in the chat, that is this entire document one that suggests a totalizing state, or is it one that is a reasonable accommodation of property? I think time will tell on that. Again, bouncing off some of the things that Larissa has said, my impression of the Constitution is that it is the draft is in considerable measures a rejection of past constitutional decisions and principles. It's a document that really stresses the importance of social and economic, social, economic, and environmental well-being of the citizenry, and it tries to get away from some of the more rigid protections of property in the past. So I'm not sure how that is going to play out with a tradition of accommodation. I certainly think that accommodation is possible, as with, while this is a much more explicit set of clauses than we have in the United States, where the takings clause is just extrapolated from a sentence that doesn't quite mean what people say the takings clause means. It's also, there's a lot of room for interpretation. And my guess is that the practical considerations are going to weigh on how interpretation is made. But I think it's going to take time. It's going to take time to establish the kinds of overall principles of interpretation that Larissa describes for Canada. That this is not going to come tomorrow or the next day, but rather will take time, and we'll see. I would doubt that Chileans would accept a totalizing state. I doubt also that the Chileans would accept rigid definitions of property that they've seen in the past. So if this constitution is passed. So as I say, we'll have to see.
So I know we're almost out of time. So if I can just jump in on that last point, Carol. So, I agree with Carol that there is definitely a move away from a very capacious protection. I'm not even going to say for property, but for value, right? To what I consider more of a protection of property, not value. And so here's what I'm reading in, and I mean, I could be wrong, as for the Chileans, I think, to really, press for answers on this, is when we shift from, a damages kind of measure of compensation to, just compensation as is understood generally, we're shifting from a compensation for loss of value to compensation for a taking of property or a taking of value. And that's different. So for instance, if the state regulates and destroys value, that's kind of damages, you should be compensated. But in Canada, we don't compensate for that. So our de jure expropriations are where the state takes title, right? So property rights outright. Our de facto expropriations is where the state leaves you with the title, but takes the value, but they're still taking something. So they don't compensate just for loss of value, just for kind of a damages measure, right? They compensate for what they've taken and retained. So value surviving in the hands of the state, as opposed to value destroyed, right? That's the measure of compensation. So I suspect that the Chilean constitution is moving more in the Canadian model, which is sure, you get your property rights, right? Indirectly, you're protected in your value too, where the state takes a value without taking the title, right? But where you're not protected anymore in is just your right to value independent of property, where the state isn't taking anything from you, but just reducing or diminishing value. So I think that's important. And where you might want to follow up is to read the difference between regulatory takings in the States and de facto expropriation in Canada. These are different models, one of which protects this more kind of capacious idea of value as such, and the other which protects just property. And then the second point I was just going to make is, look, in Canada, we of course allow that the legislature can delegate takings powers to the executive in clearly expressed terms. That was decided in Simpson and South Staffordshire Water in 1865. But it goes back to 1215 in the Magna Carta, that no free man shall be disseized or dispossessed but by the lawful judgment of his peers or by the law of the land. This is a power struggle between legislature and executive, where legislature won, supremacy of parliament. So I think it's really important to note, of course, a lot of expropriations are done through, the executive branch at some point, but there's that kind of delegation of power that's required to avoid the totalizing state, because a totalitarian state is a state that wields arbitrary discretion. Right. And that's always the worry about executive power. Right. And so thinking of expropriation as being lodged within the legislature is meant to avoid that. Right. So anyway, is it reasonable to have this? I think it's totally reasonable. I think it just seems like, maybe just less protection, though, of value, which investors have come to rely on. And so it will be, I think, a bit of a shift for investors, right? But nothing that would be out of line with liberal democracies around the world. I think Canada is totally a thriving liberal democracy. We're not scared of our state. We have great investment. I think the next panel talks more about investor protections, I think will be answering those questions with a little bit more granular detail.
So Jackie Dugard has a question for you. So Jackie, if you want, please.
Thanks very much. Thank you for a very interesting panel. I wanted to respond to something that Carol said, and it's really more directly on social and economic rights, which will maybe form a segue to the next session. But Carol, if I heard you correctly, you said that you asked the question rhetorically, I think, about who would pay for socioeconomic rights. And I always find that quite an interesting question. And I have to say that, I come from the global South where socioeconomic rights are very entrenched. So we don't find ourselves asking those questions. I always find it interesting that no one asks who pays for the military, who pays for the police. We ask who pays for socioeconomic rights. And I've always thought we should flip that question and say, who's going to pay for not having those socioeconomic rights? Who's going to pay when you have a highly unequal country with very low human development indicators, a lot of violence? In other words, when you have a country like America. So, for me, I think that is a really important question that we have to ask. Of course, we have to ask who's going to pay, but I think we also have to ask who will pay if we don't provide them. So I guess it's more of a provocation than a question per se, but thank you very much.
Thanks, Jackie.
Can I respond?
Yeah.
Well, this is actually what I was trying to get at, is that those are important interests, and there are costs to not providing those kinds, or paying for those kinds of interests too. Nevertheless, I mean, it's a balance, and the military is another example. I mean, any governmental expenditure is an expenditure and somebody's got to pay for it. So it is important to think about how that is done and to balance what you want to have done by government with the protection of property. But that's my whole point actually was to stress that you have to think about all of these things together without emphasizing one over the other, because they do affect each other.
Thanks, Carol. So we have reached our ending time. It's been a great pleasure sharing with both of you, Carol and Larissa, this panel. You have provided some very valuable insights that will obviously help us in getting implemented this clause, because as you said, one thing is the paper and the other thing is the practice, and all the things that affect the practice, many of those already exist. So we'll see how this turns out to be. So thank you very much for being with us here this morning.
Thanks, Matías. It was a pleasure.
Thank you.
Thanks, Matías and Carol and Larissa. Very much appreciated. If you're going to stick around, we'll ask that you turn off your cameras now. And if I can invite Domingo to join me. There we go. Hi, Domingo. And Nicolas and Jackie, if you wouldn't mind turning on your cameras. So this next panel that we'll get into, we've already had a great segue with Jackie's question there. I'll hand it over to Domingo to start the conversation on social rights and international investments. Thanks so much.
So thanks, Marta. Hi, everyone. Welcome again to this second panel. We have these two tremendous guests to talk about social rights and international investments. So I want to start saying, as Matías did, a couple of ideas to put the discussion in context. The Constitutional Convention, which is our constituent assembly that is finishing its work, published just a couple of weeks ago the first draft of the Constitution that will be put to a referendum on the 4th of September. The draft includes the recognition of several social rights, such as the right to water, adequate housing, and decent and sufficient pension. What is the change? The draft, I think, proposes a much more revitalized role for the state, not so much in the direct provision of rights, but in the regulation of a common legal framework for rights provision. Today, and this is important to emphasize, a part of the provision of social goods such as health, education, and the entire pension system in the case of Chile is provided through the private system that operates under the rules of the market. Now, of course, there is a public system of social rights for those who cannot afford the private provision of these goods. However, the way in which people pay, for example, for access to the private health care system is through the mandatory legal contribution. This means that I can decide whether my health taxes go to the public system or through the private system. Of course, there are many people for whom this is not a choice at all. They just fall into the public system. At the same time, it is also worth noticing that the draft also recognizes what until now was non-existent, a principle of fiscal responsibility. In fact, it provides that public finances will be conducted in accordance with the principles of sustainability and fiscal responsibility, which will guide the actions of the state in all its institutions and at all levels. Actually, these principles is repeated several times along the draft. What are the debates that have been taking place, or at least some of these debates regarding these clauses? I will only list them and then give the word to both Jackie and Nicolas. So the first one is a usual suspect when we talk about social rights. Can a developing country afford to recognize social rights? Shouldn't it first develop and then provide rights? A second topic has been one regarding the role of the private sector. Do clauses such as those found in the draft imply that the private sector will have to step aside in the provision of goods such as health and education? And last, and certainly not least, the transformation that the social rights model proposes are, of course, significant, ambitious, and structural. For example, in the area of health, it seeks to integrate the public and the private system into what it calls a national health system. What about investments, protection, treaties, and other international commitments that may constrain the changes? Without further ado, then I leave the screen to Professor Jackie Dugard first, and then to Nicolas Perrone. Jackie, thank you for having accepted our invitation, and thanks for being here.
Thank you so much, Domingo, and thank you to everybody else for this invitation. I first want to say that I'm tremendously excited about participating in this discussion, but also about the Chilean moment. I think that this is really something for all Chileans and progressive people around the world to celebrate in a time when, you know, I think there is not much to celebrate, frankly, and where social, political, legal, environmental, and economic situations seem very dire everywhere. This is really a moment of hope. And so I want to applaud and celebrate with Chileans this very hopeful moment. I'd like to first take a few seconds just to situate myself. I am South African, and I would like to just say a couple of things about the South African Constitution and the transitional process which occurred in South Africa. Of course, in South Africa, this process occurred like in Chile against the backdrop of social and economic inequality and dissent. and an authoritarian regime, although I understand in Chile there's a bit of a distance now between now and the authoritarian regime, whereas in South Africa we were deposing an authoritarian regime immediately, and the constitutional change occurred against that backdrop. But a couple of things, I think there are probably quite a lot of analogous situations. One is that South Africa is a very unequal country, and I gather that Chile is the most unequal OECD country, and that obviously that means that, to answer one of your questions straight away, Domingo, on the question of can a developing country afford socioeconomic rights, I would say that it's possible some countries really can't, that very poor countries can't, and not immediately, certainly. But I think that when you've got an unequal country such as mine and yours, then you have resources. It's about the distribution of resources. So I would always say that when you've got unequal countries, then you have got resources, and you've got the ability, if you change the resource structure and the distribution mechanism, you have the ability to satisfy the socioeconomic rights. And I would again pose the question of what is the cost of not doing that? But to talk about some of the key features of the South African transition, and that were enacted in our first our 1993 and then finalized in our 1996 constitution. Some of them that are pertinent to this discussion here were that, first of all, in terms of socioeconomic rights were, we never had them before. Then they were enacted as justiciable. They're not immediately realizable, and that's something I will circle back to in a minute. So there is a standard by which one assesses whether or not the government has fulfilled the obligations. One of the features, which I will again also circle back to, relates to something that in fact I think Carol also mentioned, this possible clash between property rights and housing rights. So a clash between a property right and a socioeconomic right, the right to housing, which happens when you have unlawful occupation. And so one of the key features that we brought into our constitution, which I will circle back to, which I don't see in your draft housing right, is a prohibition on evictions unless ordered by a court after considering all relevant circumstances. So I think that is a key issue that we brought in to ensure that people were not arbitrarily evicted. And I think it achieves a balance between property ownership and housing and socioeconomic rights. Another key feature is that some people would refer to this as nationalization, and I'm sure there are people on this call who are going to freak out. But we essentially are in one move in terms of mineral rights and water rights, made the state the custodian in two, both in the constitutional ambit, but in two key pieces of legislation. So now the state is the custodian of all water rights and all mineral rights, and you have to apply to the state to get a mineral license or water license. The old order, in other words, the previous licenses, were, in the words of one of the key cases on this, legislated out of existence. And yet the courts have not found that to be expropriation without compensation. So I think that is another key feature that I will circle back to as well. In terms of expropriation, because of course, in South Africa, we had widespread colonial and apartheid dispossession of land. So there is an expropriation provision, which allows expropriation in the public interest for just and equitable compensation. And actually, I think it's quite important to put that equitable in there. So I would, highly recommend that addition. And again, I'll come back to that. Why is it important? Because I think, and also as I believe that Larissa was mentioning around Canadian rights of expropriation, we can, in the South African situation, in relevant circumstances, provide zero compensation. But in any event, I think it's critical to say just and equitable rather than market compensation in order to achieve the social value of land and property, etc. And so these are some of the key features. I'm naming a few that I'm going to circle back to when I comment on the specific clauses of the draft constitution. But what I wanted to, the point I wanted to make in relation to these is that there was no adverse impact on investment. Investors continue to invest in South Africa. We have high FDI. We are now moving, we have bilateral investment treaties, but we're moving, like many developing countries, we're moving away from bilateral investment treaties. And I think that I've seen some really interesting research showing that bilateral investment treaties are actually always bad for the developing country, always good for the developed, and that not having them makes no difference at all to investment. And that having a human rights framework and a clear, legal certainty is just as important. So I think, regarding investment, I can certainly say from the South African perspective, having this constitution that some may regard as radical and certainly as progressive and transformative has not adversely affected investment. So I'm now going to quickly just turn to some of the general issues from my perspective about the socioeconomic rights clauses. So I think picking up on a point that Larissa also made, that much, and I think Carol as well, that much is obviously going to depend on subsidiary legislation. You obviously cannot cover everything in a constitution, and I'm not sure the extent to which that broader legislative reform is part of the process. It was 100% part of the process in South Africa. We had to reform everything, all law as well. So I think in particular to the 1981 Water Code in Chile, which I'm very interested to know whether that is going to be reformed as part of this process, because I can see that there might be some problems there. Then much will also depend, and I think this is a point that both Larissa and Carol have also made, much will depend on the judiciary and how it adjudicates these matters. So, broadly speaking, there are questions of the standard of review that's going to be used. Is it going to be as per the international law at the international level on the International Covenant for Economic, Social and Cultural Rights about the minimum core, or is it going to be more how the optional protocol to that covenant deals with it in terms of reasonableness of the policy, which is how in South Africa we adjudicate socioeconomic rights about reasonableness of the policy, which then raises the questions about whether these are going to be individual remedies or programmatic. In South Africa, we pursue programmatic remedies. There are pros and cons to both. I know that Chile is a civil law jurisdiction, whereas South Africa is common law, and in civil law jurisdictions, I think individual remedies are generally given, but you don't have a strong socioeconomic right. So that's a question. I would just say that sometimes programmatic can be better because, as the experience from Brazil has, and I know some people disagree with this, that once you have an individual remedy, you can have capture by the middle classes and above and crowding out of poorer people, but these are just things to consider. And then legal education would obviously be absolutely critical because these are going to be new rights and how to adjudicate them. And we all know judges are often not very amenable to legal education. So that is a tricky one, but a very important one. And then my final general point is that it'll be absolutely critical for socioeconomic rights to apply horizontally to private actors, including through tax. And here we circle back to that question or comment of Carol's. And that I think it is going to be absolutely essential. Frankly, I've never heard of a situation where people cannot pay tax for example, healthcare. I don't know if people pay tax for education. I mean, I myself do not have children, but of course I must pay tax for education for other children. And of course, even though I buy myself out of the medical system in South Africa, I must of course pay tax for that. For me, it's anathema to think of anything else. And I think it's be absolutely critical. I'm not sure, I think I probably don't have very much time, so I'm just going to make some quick comments about two of the rights, water. So one question that I have is about the combination of water and sanitation. It's very controversial, and sanitation is an important thing to have as a right, but most sanitation in most countries is not waterborne. So you end up with a problem about hitching sanitation to water. In some countries, and for example, in South Africa, we've actually gone back and forward, but when it's worked best, it was hitched to housing rather than to water because of this problem. But of course, the overwhelming issue about water is about private ownership and distribution. And here, interestingly enough, just today, there was an article in The Guardian about how 50% of people in Chile live in water scarce areas, and that apparently Santiago's already had water rationing. So the questions are whether your constitutional clauses are going to be very clear that this water rationing, any water rationing and the distribution would affect everybody, not just poor people, that rich people would also be affected. And then I think that the sticky question pertains, as I see it from the clause as it is, pertains to existing water property ownership and existing water licenses, and how one redistributes those and how one ensures that there is custodianship of water in general. So that, and again, just to say that in South Africa, we moved right away from that straight away, and were able to, and litigation was brought, but it was never considered to be expropriation. It was considered to be regulatory regime change. On housing, just a very quick comment. I think that on housing, the clauses are a bit vague for me. For example, what does it mean for the state to take all necessary measures? How could you adjudicate all necessary measures? And the state will guarantee the availability of land. What does guaranteeing the availability of land mean? And again, how would you adjudicate that? And then the glaring omission for me here in the housing clause is any protection against eviction, which I think is just an incredibly important protection to have. So thank you. I think those are my comments about the socioeconomic rights clauses, but again, very excited about this moment in Chilean history. Thank you.
Thank you so much, Jackie, for your remarks on the draft of the Chilean Constitution on social rights. And now we turn to Nicolas, who will address the issue of international investments in the context of possible social transformations. Nico?
Thank you, Domingo. It's a pleasure to be here today. Thanks for the invitation. And so the first thing I want to do is I think we're having a conversation with Carol, Larissa, and now Jackie. There is a more general conversation about the relationship between equality, inequality, property, investment, and social and economic welfare. And I would try to resist of seeing these things as antagonism or one being to the detriment of the other. You do need a healthy economy to cover for a good life for people. And at the same time, there's the only reason you want a healthy economy, I think, is to have a good life for people. So these two things, I think, go hand in hand. And this is presently recognized by the IMF, for instance, which is saying that actually equality is related to growth, to economic growth. So I wouldn't see these two things as antagonists. I think it's the first thing. I would actually see that the two things can go hand in hand. And I think there is an effort in the Chilean draft of the new constitution to make that possible. And of course, there's a lot of way to do that, a long way to do that, and implementation will be key. Now, let's go straight into the question of international investment. You may have heard that there were a couple of discussions about including specific provisions in the constitution about investment treaties, free trade agreements, and investor-state dispute settlement. These provisions were discussed, but eventually did not make it into the draft. I think that's important to say. So presently, the draft says pretty much what most constitutions do say about these things, which is like the executive negotiates treaties. And when these treaties touch with questions that relate to the law, the constitution, they need to be ratified by Congress. This is pretty much standard, and you find that in most constitutions. And so I think that doesn't add anything on that at that level. What is important is that a guideline. So it's not a mandatory provision. There is a guideline for the administration, for the executive when negotiating these treaties, that ideally any dispute should be judged by judges or permanent judges and not arbitrators, that is ad hoc quote unquote judges or private judges. And so there is a call to have impartial and independent tribunals, as opposed to what some people have said, like sometimes ad hoc judges or arbitrators are not ideally placed to decide questions of public policy. And then we could discuss more about that in the questions if you want to. So I would say that the new draft of the Constitution is pretty much only offering a platform for rethinking some elements of international economic law, but it's a guideline. It says preferably. So actually, there's nothing there that would require Chile to renegotiate or reconsider current free trade agreements or investment treaties. But what about this platform? Does it make sense, that like this sort of signal that the Constitutional Assembly is giving this signal? Does it make sense to give this signal at the current moment? Well, actually, I think it does, because if you look at what the US has done, for instance, reconsidering the NAFTA. So Larissa mentioned the old NAFTA now is US, Mexico, Canada Free Trade Agreement, or USMCA, where there's no ISDS between the US and Canada, and there's only ISDS for the oil and energy sector between the US and Mexico. So ISDS was removed, and not only because Mexico was complaining, there were many concerns in the US and in Canada as well. So you see that there is other places where at the policy level or under constitutional, below the constitution, at the level of the law, there were views of making changes, and that's actually happened in the US, Mexico, Canada context. And the same has happened in the European Union. There were many voices, particularly in civil society and academia, against investor-state dispute settlement. And the EU took the decision to go for a permanent court. That is still unclear how it will work. But again, we see that the same concerns that have made it into the constitution, into the draft of the Chilean constitution, are present in the EU, and there is discussions over that as well. And I also think it's important to mention that the OECD is currently has launched a proposal, or is a platform to reconsider investment treaties as well, as long as in relation to the problem or the challenge of climate change. And this is important to the extent that some of the reforms that are necessary for a green energy transition may impact some existing rights, for instance, from fossil fuel firms, oil firms, and these firms might want to get a compensation. And there are ISDS disputes against Germany, against the Netherlands and Canada, that signal that these firms might go for this. And here it's important to keep in mind history. I think what Carol was saying in the beginning is very important. Why do we want these property rights? Why don't we want investment protection? So the origin of investor-state dispute settlement and investment treaties goes back to the 1950s and 1960s. And the firms that were openly and actively looking for this kind of protections were all firms that were concerned about decolonization in the global South. So all firms wanted to use this mechanism to protect their rights in the background of decolonization. And it's all firms, again, that are using the system to protect themselves against measures for to go for a green energy transition. So overall, I think it makes what Chile is doing is pretty much standard in this regard. And it's important to point out that it's slightly different from what Bolivia and Ecuador did, which is to include specific provisions prohibiting ISDS or prohibiting some other form of limiting, investment treaties and free trade agreements. And this require for these two countries to go and quickly either renegotiate these treaties or terminate them. And this created a bit of a noise for investors. But Chile, with this, if this new constitution is passed, will not have to do that, because, as I said, this is just a guideline. So existing treaties are remain within the context of the possible new constitution, and the same happens with free trade agreements. So I think this gives you a sort of a background of what's happening between investment treaties, ISDS, and the new constitution. Then I think it's important to go to the more specific reforms that may happen. And I think Jackie was touching on some of those, like water reforms that relate to the health system, the education system, care. And here I think it's irrelevant to mention that investment treaties, as was mentioned by Carol and Larissa, they protect assets, they protect, perhaps, depends on how you interpret them, value, but they do not protect the possibility of certain changes. So it's most likely the case that the constitution per se will not affect any right at all. It's the implementation of the specific measure that might do that. So the constitution as such does not, that's important thing, does not impinge on any right, and probably will not do that. But of course, it's true that reforms that relate to the health system or water rights might mean new regulation, might mean a new type of rights, so an exchange of existing rights for new rights. And it might mean the extinction of some rights too, and then there might be a transition mechanism. So here, yeah, it's important to keep in mind investment treaties and investor-state dispute settlement when it comes to these specific reforms, particularly if there is extinction of rights that they may require compensation. But again, I think it's important to keep in mind context. Currently, there is a lot of discussion whether fossil fuels should be compensated for reasons that we could discuss later on. So I think that's relevant, even extinction, if that would require compensation. But leaving that point aside, of course, you have new regulations that might have created some noise for investors. You might have an exchange of rights. And I think in this regard, what is important to keep in mind is that whatever it's going to happen, ideally, and I think this is the message that has been said by the administration, it will be something that will be considering the different options, will be having an open and honest conversation with investors, and it will be, following the due process. And more importantly, it will not be abrupt and sudden changes. The idea is to have a dialogue, a conversation, and a transition period. So, I mean, there is a lot of, signal to investors already that change is happening. And I think that for investors that really want to stay in Chile and enjoy all the possibilities, the investment opportunities in Chile, it will make a lot of sense actually to try to adjust and have a serious and honest conversation with the government. It's only investors who want to exit the country who might then go for ISDS or suing the government, because actually what happens most of the time is that when investors want to remain in the country, they are normally open to have an honest conversation. And on the other hand, what I see in the new constitution is a call for firms to follow ESG, that's environmental, social, governance standards. And I think most investors that praise themselves of, being sustainable investors are very engaged with these standards, and the investments like to comply with business and human rights standards. So actually, then in that regard, what the constitution is and these reforms will be doing is try to get that balance I was talking about in the very beginning. So I think that it's important to keep in mind that the changes that Jackie was talking about, are changes about like not only just legal provisions, but it's also about a try to change the economic development model and to move more towards sustainable development and inclusive development. And so to the extent that this is going to happen gradually, it's going to happen in a way that is committed to the due process, and there's no sudden and abrupt changes, then investors will have a lot of time to make calculations, to modify their business model, to ensure that the situation is in line with their investment objectives. And there's going to be a moment, there's going to be a space for having a dialogue with investors, with the government, sorry. So I think that the mantra here is no sudden or abrupt changes, but on the contrary, transitions that allow investors to adapt to a different environment. That I think makes sense for everybody, not only for locals or for Chileans, but also for investors who, as I say, I mean, they're also concerned about the environment, and they're also concerned about human rights. There's no foreign investor, there's no mining company that says, oh, we're going to your country to violate human rights, we're going to your country to deplete you from water resources. The message you get from most responsible foreign investors is actually that they really care about these things. So, I mean, if they do care, this constitution provides a good opportunity for them to align their standards, their corporate social standards, and their ESG standards with the new constitution. And I wanted to say one or two things also about the free trade agreements, because here again, you see that there's no changes at the constitutional level, but there have been discussions about the need to align those, again, with a model of sustainable and inclusive development. And I think here what is important to keep in mind is that what Chile will be doing is to have a conversation hand in hand with the other treaty partners to see how to align these treaties with sustainable development and climate change. Again, this is something that is happening with other treaties. It's something that the EU is doing. It's something that is being done in other places. And I think what is important here is to keep in mind that for Chile, there are important natural resources like lithium that create a great opportunity, and it makes a lot of reason, I think, that the government and people in Chile want to make the best of lithium. That, of course, would imply not only extracting the resource, but also developments and investments in research and development and in technology and innovation. So this also opens new business opportunities, and investors all over the world might see this as new ways of doing business in Chile. So I would say here again, new spaces for international collaboration, for a collaboration that it has to be sustainable. I mean, I see these goals more aligned with the Sustainable Development Goals of the United Nations than what is in the old constitution, and in that regard, I think it's important to keep in mind, as I said in the beginning, that investment should not be seen, and the protection of investment, the protection of property should not be seen only as an obstacle, but also as an opportunity to make social and economic rights possible. So I would end it up here and look forward to your questions. Thank you very much.
Thanks, Nico, and thanks for sticking to time. So we have a couple of questions on the chat. The first one is from Javier. I think it's related, of course, to water rights, Jackie, and she's asking whether these new regulations may affect how farmers build new irrigation structures. That's the first one. And the second one, also on water rights, is whether you can tell us what has been the experience in South Africa in transitioning from a regime that regarded water as a mere economic resource to another one where it's considered a right. Was there any change, challenge that was possible to mention because of this transition?
Thank you. Thank you for those questions. I'm not sure I 100% understand the question about the water infrastructure. Could you repeat that again? And I wonder whether it wasn't dealt with in the previous panel. Is it about property rights? Or is it about the right to water?
Well, the question is just that, and it came up when you were talking about water rights. So that's the only I can tell so far.
And if you can just repeat it, sorry, please.
So do you think that the new regulations on water rights may affect how farmers build new irrigation infrastructure?
I'm not sure I understand, but if the question is whether you have to have a direct property right in order to, perhaps it's something about whether you have to have a right to property in order to build infrastructure on it. And, that would depend on the regulatory regime in Chile. I'm not sure I can answer that question. But onto the question about the South African situation. Interestingly enough, there hasn't been any challenge on the transition. The transition to, if we want to put it in radical terminology, nationalization of water. There really hasn't been a challenge, but there was one on the exact same scenario with mineral rights. So we have an act, it's called the Minerals and Energy Petroleum Resources Development Act. And when that was brought in, that created a new regime in terms of which people who had what they called old order mining rights, that's roughly speaking in the South African context, white people. So those old order mining rights holders had to apply for conversion to new order mining rights. And as I said previously, the old order mining rights were legislated out of existence. They ceased to exist. And, you know, this is the wonderful thing about licenses. You can do that type of thing. So this transition, in terms of this transition, if you were an old order mining rights holder, you had to apply to get a conversion to a new order license. And to do that, you had to satisfy various social requirements around transformation within your in your mining company. Were there Black shareholders? Were there worker rights? Did you provide housing for your workers? These sorts of things. So in order now to continue to hold your rights, you had to satisfy these transformation criteria. There was immediately a legal challenge and by some old order rights holders. But our constitutional court established that this wasn't expropriation without compensation, that it was regulatory regime change, which we allowed, and that it was a legitimate purpose in terms of the transformation agenda in South Africa. So I don't know, in obviously one country's context can't be replicated in another. So I wouldn't like to suggest how it might play out in Chile, but I would say that ultimately these things are not, it's not nuclear physics. It's all about the politics, and the law can be pushed to certain frontiers, but the question is always going to be, is the political arena going to accept it? So I would always say that that's where the problem generally comes in terms of the political rather than the legal per se, but obviously the legal can be the way in for a problem to be raised.
Thanks, Jackie. So Javiera just it's clarifying her question. She says the new constitution changes water rights for administrative authorizations, which don't have property rights. If farmers can have ownership on water, will they be willing to build new irrigation infrastructure?
Yeah, so it's what I thought it was. It's this idea that will you invest if you don't have a property right? But I think people do invest. People do invest regardless. If you have a farm and you want to improve it, you want to gain a lot of different you want to feed your crops, you want to water your crops, you probably are going to invest. So I think that around the world there is a lot of evidence. For example, in South Africa, in informal settlements, that people don't own that property, they invest in upgrading, even though they don't own that property. So I think that, you know, I would say yes, but I guess we'll have to see.
Thanks, Jackie. Nico, Javier is also asking, China has made important investments in Chile, and there's a deal to avoid double taxation. Could the new trade guidelines affect current Chinese operations in Chile?
Thank you, Domingo. Let me add one thing. So I think what Jackie was saying is very important. It's very important to see what's happening on the ground. It's very important. That's why I insist on this need for dialogue. I think what is relevant is to have people sitting on a table and have conversations about these questions. I mean, about whether what kind of regulation you need for water for farmers to keep being able to continue doing what they are doing, but at the same time you have water for human consumption. You cannot just forget about the social economic well-being of people. And I think what happens on the ground, it probably differs from country to country. It probably differs from culture to culture. It probably differs from many different points. So I think it's important to, both for academia to create that knowledge as well, if it's not there. So more research needs to be done. So sometimes assumptions and stereotypes don't work that well. And I think there is a lot of, sometimes these conversations happen on the background of certain assumptions that are not really quote unquote real. It's not really what's happening on the ground. So as Jackie was saying, people might be investing even if there is no water protection, or they might not be, but we don't know. And it's very important that we get clarity about this question. It's not just a discussion on the basis of ideas or papers that we have read that are not related to Chile and the culture in Chile and how people relate to property in Chile. So going back to the question about Chinese investment. So actually the answer is no. There's nothing in the constitution suggesting that any treaty will be modified or changed. As I said, the decision has been to keep this at the level of the law, at the level of the executive and Congress, and then if there are, to the extent that the executive and Congress decide to, have a mutual rediscussion, a bilateral, multilateral renegotiation of these treaties, that this might or might not occur. And of course, you always need the other party to be engaged. I think what is relevant when it comes to investments from China is something slightly different from the constitution, but the political economy currently between the US and China, this trade war that creates problems for countries in the global south that sometimes are being pushed to show alliance either to one or the other. Historically, what most global south countries always wanted to do is to get, enjoy the best opportunities that are out there without having, political repercussions. So if a Chinese investor is providing the best for Chile, then I guess it makes sense for Chileans to go with the Chinese investor. And the same if the investor comes from Canada or the United States. Sometimes, unfortunately, politics gets involved in these questions, and there are signals, political signals saying, oh, if you go with Chinese investors, then there's going to be repercussions from the other side or the other way around. So hopefully this will not happen, and then Chileans and people in the global south will be able to choose the best investors and the best opportunities for them, without having to pay attention to being politically, just whatever it is, it makes economic sense for them without the political elements there. Thanks.
Thanks, Nico. I see Professor Rose with your hand up. So, Carol, please.
Hi, Nico. I was very interested in your focus on the conversation between foreign investors and the Chilean government about how to proceed with foreign investment, with treaties, with protection of property or not. And what I was wondering was, as I heard this, I was thinking, I wonder whether this kind of conversation might begin to establish a kind of tradition of moderate interpretation that Larissa was talking about in Canada. Not part of the Constitution, but part of constitutional interpretation that might come out of conversations with people who are not necessarily governed by the Constitution, but have concerns about investment, about what their rights are going to be, who are also concerned about future investments in sustainability and extension of social rights and so forth. Do you think that those conversations with foreign investors can then carry over into the way the Constitution is interpreted, even internally?
Thanks, Carol, for the question. I think yes. I think the answer is yes. I think there is, so here, as I say, I'm not speaking on the constitutional text as such. I'm speaking just following the news and what, the signals that the administration have given, that dialogue and conversations are very important, and know that they often have spoken against abrupt changes. And I think that's, as you're saying, that there is this question of, trying to build or create a tradition of how you do things, a custom of how you do certain things. And so, as we know, procedure sometimes is very important to protect property and investment. It's not just substantive procedure, but substantive protection, but also procedure that is relevant here. And I think it's important to keep in mind also what is at stake in the Chilean context. It's a lot about natural resources, water and minerals. And these projects in general have, an important impact on the entire community. So you have indigenous peoples, you have the local community, you have regional governments, you have the central government, and all these actors have different interests, and the foreign investor, all the local investors, all these actors have different interests. And I mean, part of the discussion about the new constitution is also about, decentralization and moving, like Chile is a very centralized country, moving some of the things that are happening in Santiago to the regions. And I'm speaking at the moment from one of those regions. So I think there is that conversation that could really, create the sort of, make tangible and real some of the promises that are in the constitution. And my sense is that if investors see that this dialogue is happening in an honest and in a way and in good faith, and they really want to continue doing business in Chile, they will be very open to make adjustments, as the one they were asked in the context of South Africa, as you know, providing for more, I don't know, how if they need to provide housing for workers and they need to take more seriously the environmental protection and things like this. And also that speaks not only for the reputation of Chile as a country, but also for the reputation of these investors. I think altogether that probably makes sense, and we should be, I think, thinking more in terms of process and procedure than in terms of substantive protection for these important transformations. I think that, yeah, so I would agree with you, and I think that's important to keep in mind that that could also then feed into a sort of constitutional tradition and feed into the legal decisions on how to accommodate the different interests.
Thanks.
Thanks, Nico. So I have one last question for Jackie regarding the right to housing. If the right to housing is recognized, will it be more difficult to evict people who illegally occupy houses? I know this is, you have a rich jurisprudence regarding evictions. And if I may add something, this is not actually an extended problem here, but we have a huge wave of migrants coming into Chile. And news have been showing that they have started to place themselves in fiscal lands or governmental lands that have been there for some time. So government is now facing the problem of how they're going to evict or move these people. So which would you say about that?
So as I said, in South Africa, we have definitely strong rights for unlawful occupiers not to be arbitrarily evicted. Now, when I teach this to my students, some of them are in a state of shock, and you see some maybe want to throw up. But you realize very soon that how this works out in reality is it's not that you're watching TV, 700 people arrive in your garden and you can't do anything about it. It's not about that at all. It's about situations, and perhaps, Domingo, that what you're saying about the situation now evolving in Chile is perhaps pertinent there, is that where you have scenarios where very poor people without access to land or housing, they have to exist somewhere. So sometimes they would occupy often public land. Usually they would go for public land before they go for private land. And then in that situation, what the court would have to do is weigh up the equities. They'd have to weigh up the situation of, you have whether it's a private landowner or the state who owns the land, you have their private property interests, their interest in vindicating their property rights, and you have to weigh that up against the interest of people who have nowhere to go, nothing, no accommodation, no land. And in the South African context, how that weighing up occurs in a court is where you have desperately poor people who have no alternative. So in other words, on the market, they cannot find accommodation, the rentals are too high for them, they cannot find access to housing. Where that is the case, the court will say that the property owner, whether the state or a private landowner, has to tolerate that infringement of their property rights for some time. Now, if it's 100,000 people, which we have had cases like that, 100,000 people who end up on your farmland, generally speaking, what will happen is that there'll be a question about whether the state pays you, whether it expropriates that property and pays you, because there is absolutely no way that a court will find that it is just and equitable to evict 100,000 people, because they would not be able to provide housing. In South Africa, we now have the jurisprudence that it is not just and equitable to evict unless the state can provide housing, alternative accommodation. I just want to be clear that that doesn't mean a 4-bedroomed villa. That means emergency shelter. So if you cannot in South Africa get an eviction order unless there is emergency shelter. If you've got 100,000 people you're trying to evict, there will never be emergency shelter. So an alternative plan needs to be made, including in some of the cases, a very innovative constitutional damages to the owner of the property being paid for that infringement of their property rights. But for the reality is that if I am a landlord and I have a tenant who pays me $1,000 a month, I'm going to be able to evict. I still have to go through the court, but the court will consider that it's just and equitable to evict because my tenant can find alternative accommodation on the market. The problem comes when you have extremely poor people, but when you have extremely poor people with nowhere else to go, you have a social problem that society as a whole, including property owners, has to address. So yeah.
Thank you, Jackie. So we have no more questions. And on behalf of the Programa de Derecho Público de la Universidad Diego Portales, I would like to thank Professor Rose, Professor Katz, Professor Dugard, and Professor Perrone for having accepted being here. And if Matías and Marta can join the screen, we can have a final general commentary if you want. And also thanks to Jairo for the translations. Thanks, Jairo, for everything. So I turn the screen to Marta. Marta.
Great, thank you so much, Domingo. I would like to invite Nicolas if you would like to join us as well. Thank you all. I would like to just open the floor. If anybody wanted to make a final comment, I know, Carol, you sort of seemed like you wanted to say something else on something. Larissa, no? Everyone's good. All right, well, with that, we will close this session. I really appreciate all of your participation. This, as we mentioned at the beginning, this is meant to be the beginning of a series of events on the constitutional process in Chile. So please keep your eye out for upcoming events to discuss other clauses as we move forward. And we will also be posting the video of this event in both English and in Spanish on our website later today or tomorrow. So please keep your eyes out on that. And with that, we'll close this event. Thank you all again. I appreciate all of your time. Thank you.